Welcome to this Conveyancing Matters chat when Stu and I discuss, will ending leasehold really happen? Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property. So, Stu, we're going to chat this week about, will ending leasehold really happen? Michael Gove, at the very end of January, sort of across the national press, telly, everything else is widely reported as saying things like, he wants to end the outdated and feudal leasehold system. And he's, said that he wants to bring changes in before the end of this parliament, which of course is, literally the next 12 months or so, because, there'll be an election in 2024. And he says he wants to make it easier for leaseholders to buy out their freeholds, and so on and so forth, and is looking closely at leasehold. So, Stu, there's 4.6 million households in England and Wales that are held on leasehold. I mean, where's our starting point with this? Where do we start, for goodness sake, mate?
Well, I think my favourite part of the interview was when he said, if you buy a leasehold property, it should be yours. It just seems a bit of a strange kind of statement and a strange article to put out at a strange time on the back of everything that's been going on lately with leasehold properties. And, putting that out in the, to the public as a whole, goodness me, it makes a scary reading for somebody that's potentially just about to buy a flat or a leasehold property, doesn't it?
Well, it does. Well, you posed the question when we were on off air, Stu, so let's talk about that first. You said, why do you think Michael Gove said that now? And we both came up with a few ideas. So end of January 2023, why did Michael Gove say, essentially, I want to end leasehold in its current form?
I've got absolutely no idea, because for me, the timing of this statement, when I think we'd all clearly agree, he's not about to abolish leasehold properties, are we? So, he's kind of setting himself up for a bit of a fall. You can go down the political agenda and making statements deflecting from other things that are going on at the moment, which is probably the likely scenario. But as a generalisation, I think we'd all agree we're not about to abolish leasehold, or are we?
Well, I think it's the or are we, isn't it? I mean, I agree. I do think quite often, I mean, I'm no politician, as is patently obvious, but you do wonder whether there were sort of other things going on that meant that, getting this out there, deflected the public's interest from something else that the government didn't want us to have a look at. And I have to say, I don't say that with any sort of political position in mind. It's just, I think, a fairly general thing, really. But I also wonder, and frankly, I'd like to ask him, I've got to say, whether it was just one of those sort of off-the-cuff comments that actually, dare I say, doesn't really demonstrate that Mr. Gove knows exactly what he's talking about in terms of leasehold. Because your point, Stu, is quite right. If you buy a flat, it should be yours. Well, that to me demonstrates a fundamental misunderstanding of the basics of leasehold, as in, definitely, why do we have leasehold? Well, we have leasehold because in the freehold context, you, broadly speaking, can't enforce a positive obligation effectively. So the whole point of leases is to enforce positive obligations such that, service charge and all the rest of it can be recovered. That's the fundamental point of having a lease. Now, quite rightly, I think people are focusing, of course, unequivocally on Grenfell and the sort of terrible, direction of building standards and everything else in more recent years, and the fact that we've sort of heard from, frankly, lots of property developers, really about the abuse of the leasehold system. But of course, all of that, to my mind, Stu, doesn't mean we should necessarily throw the baby out with the bathwater from a legal point of view.
No, we're generalising, aren't we? I think that's the problem here. So we can take into account, all the bad parts, but to criticise leasehold as a general, and also I just think the timing's a bit strange as well for me. When the market's very volatile, to potentially put off people buying leaseholds, which if you didn't have an understanding, you have to admit this article would scare you, wouldn't it?
Well, you say this article. It's been widely reported.
Widely reported, yeah. So
all over the news. He was,
yeah.
I think, in the Times, the Mail. Everyone was reporting it.
Yeah. So this statement, if you like, at a time when transactions are potentially falling, and we could be entering into a period of lesser volumes, I'm not sure that any positive could come from it.
No, I agree. And I sort of posed the question really to myself, Stu, when I was thinking about this, Chad. Is it realistic to sort of pose the question, will ending leasehold really happen? And, if you buy a flat, it should be yours. Are either of those things realistic? And I think the answer certainly in the short term is no. And without going into the detail about it, let's look at the Building Safety Act as an example. Not all in force yet. It's taken 5 years to sort of get onto the statute books. It's very, very complex. Absolutely the law of unintended consequences. There's so much complexity. And of course, as we've sort of alluded to before, Stu, what's your view as a firm on the current, and there's bound to be more, sort of Nationwide and Barclays requirements around building safety and cladded buildings? You wouldn't.
It's a total nightmare, isn't it? So again, to cloud those current issues that are probably at the forefront of everybody's kind of mind at the moment, with a sweeping generalisation that all leaseholds are wobbly, is crazy.
Yeah, crazy. I think so. I think so.
And like you say, whether it's coming from an angle that's potentially, maybe things are out of context or whatever, I don't know. But, we can go on maybe to talk about common hold in a second to a degree. But I just think the whole thing's crazy. Realistically, all those leaseholds, can you imagine the logistics of abolishing leasehold? Crikey, it would have to be a whole cultural kind of shift. Well, you just couldn't even contemplate it. Can you imagine speaking to our friends at the Land Registry now and talking to them about abolishing leasehold?
I know.
Crikey, it'd take us another 50 years, I think, to do that.
Well, mate, that'd see us out, I suppose, mate, wouldn't it? But I think this is the thing. I think this, and it's not to say that technically and legally anything isn't possible, because of course it is. But the Building Safety Act is a classic example. Stamp duty land tax, actually, in my opinion, is a classic example where you have a central single principle. What's the principle that brought about the Building Safety Act? The fact that leaseholders should not be trapped in unsafe buildings and required to pay for something that was not their fault. That's the central premise of the Building Safety Act, and that is unarguable.
Yeah.
And even if you look back to the beginning of stamp duty land tax, when, good old George Osborne, the basic principle about one of the basic premises around stamp duty land tax was actually trying to find a vehicle for, buy-to-let landlords and people buying more than one property paying more stamp duty. That was the principle. And look how complex those two things have become.
Mm-hmm.
They are standalone and reasonably straightforward. And so you imagine, as you've just said, trying to scale up, unpicking leasehold for 4.6 million properties. Those properties would become unsaleable for the transition period. And of course, my question always is to legislators and anybody else, Stu, what are they going to replace it with?
Well, we have got something, of course, that. And I suppose you could argue this is not old news per se, or new news, insofar as, common hold came in. Can you remember when common hold was first thrown into the mix?
Yeah, the statute was around 2002, wasn't it?
Yeah, it would have been. Yeah, so 2002 that came in, and I can remember sort of training at the time and all the different things that were going to be thrown into the mix. And did it take off? No, it didn't. And why didn't it take off?
Well, I have my theory on that, Stu, because I have a theory about just about everything.
Go on then, hit us with the theory.
Well, and the thing is, it does feed into a lot of what we're talking about today, though, and a lot of the problems, because my theory on common hold not being taken up was that the developers didn't want to take it up. And my big theory, and I could be wrong, and if any of the big developers want to come on and talk to us and put me right, very happy to be put right. But one of my big theories on this, having been on the receiving end of, big developer contracts and paperwork for years, is they probably just didn't want to sort of, unpick all of the documentation for their new developments. They didn't want to start from scratch. They'd already got their solicitors, they'd already got their big conveyancing firms set up with stuff. So if it's not compulsory, why would they do it? Why would they have spent
this always goes back
on new documents?
Yeah, it goes back to when I say cultural change. For me, unless things become mandatory, as an industry, we are very much against change, aren't we?
Yes.
So again, it was never going to really take off unless everybody was on board. And I suppose historically, if you look back over the years, every time something new comes up, are all, parts of the industry consulted, and, not really, are they? When HIPs came in, to all the things that have happened over all the years, unless things become mandatory, like HIPs did, it doesn't happen.
And of course, SDLT.
Yeah, of course, yeah, all of that. And then you go back at who's consulted, and often the lawyers are left out, aren't they?
Well, I think the interesting and subtle point, Stu, and that certainly this is something I've read from sort of commentators on the Building Safety Act, it's not necessarily kind of lawyers per se who, presumably are involved in the drafting of this stuff, of course, but it's actually, the profession, the conveyancing profession. It's us that's going to have to put this stuff into effect on a day-to-day basis. So if anybody had put the, draft, deed of certificate, which is such a terrible name in itself, under the Building Safety Act proposals in front of any conveyancer would have said, well, that's a self-certification exercise. How's that going to work in practice? Massive I still think that the prospect of fraud around the production of those deeds of certificate, that's where the big risk lies. But we're expected to put this stuff into practice and nobody consults us. And it would be exactly the same around leasehold. It was exactly the same around common hold. It's all very well introducing this stuff, but if you aren't involving the people who are going to be at the coalface doing it day to day, if you're not involving people like you at the top of firms who've got to pay the indemnity insurance, then it's not going to work if we don't have to make it work, is it? But it's not because we don't want to make it work. It's
100% agree with you. 100% agree with you. And we can go back to chats we've had about numerous things, such as reservation agreements and, upfront information. The same thing still applies until it becomes mandatory. I don't think it will take off because there's too much of a shift in law firms even that would need to take place to implement these things. There are firms that are forward thinking that want change, but of course there are firms that necessarily don't want that as well, that are happy with what they're doing and the systems that are in place.
Do you know what? I'm going to jump in there, Stu, because I don't agree with you, because I think this can sound quite negative. This discussion could sound quite negative, and we're saying, oh, conveyancers don't want change, and I think it's much more subtle than that, because actually I think a lot of conveyancers at the coalface and a lot of conveyancing firms, do cope with an enormous amount of change. The regulatory burden that's just exploded in the last 5 to 10 years, that all has to be sucked up. That risk has to be sucked up. The last 2 or 3 years with the stamp duty, land tax, no holiday, lockdown, pandemic, the whole 9 yards, we do suck up an enormous amount of change. So I don't think it's that firms don't want change per se, but I do think it's an assessment by firms of risk. And well, why would we do this if all we're going to do is be taking on more risk? And I mean, nationwide.
No, yeah. I mean, I didn't say that people were not willing to change if the idea was a good one. That's half the problem, isn't it? It's were we consulted, but quite often we're thrust upon ideas and theories by people not within our industry that we then have to adopt. That's the problem.
And do you think, something's just occurred to me, Stu, do you think the reason for that is actually that as a profession, conveyancing is not respected these days?
Without doubt, it's not respected. I mean, if you go back, I don't know, 20 years when I first started, 25 years ago, clients would come in to see you wearing a suit.
Yeah.
I mean, God forbid, they'd actually book an appointment, can you believe? But not only would they book an appointment, they'd actually come in a suit because you were respected. But I think over the years, our sort of, I don't know, bargaining position within the moving industry has lessened and lessened and lessened. And whether we talk about estate agents a lot, don't we? And different sort of powers within the moving industry. Their sort of status has probably gone up, hasn't it? From a PR point of view, even from a finance point of view. The power brokers are involved in the moving process are predominantly not conveyancers.
Well, or if there are, they are, they're not lawyers who are running, conveyancing firms that probably make a lot of money but don't necessarily deal with
a lot of people driving change within the conveyancing industry are more sort of tech platform-based entities, I would say, than people that are practicing conveyancing on a day-to-day basis.
Yeah, absolutely. But I think the fact that conveyancing as a process has become within the legal profession, and therefore the people looking into the profession, it has become maligned. It's seen as
it not always?
I think
always seen a bit of a poor relation.
I agree, but I do think it's become a lot worse in recent years, and there's quite a snobbishness from other members, other people within the legal profession who see conveyancing as somehow the poor relation. And maybe because, maybe we've all sort of maybe allowed that to happen. That's perhaps
I think that's always been the case. I think it's that's a kind of separate argument. If you look within the legal profession, I would say that's always been there. But for me, it's all about sort of external influences and the way everyone's trying to drive everything to be a tick box process. And of course, as we said 100 times over, it's not a tick box process, and every individual person has different needs, and every individual property has a different title and can be a completely different transaction. And trying to standardize the whole thing is where we have the loggerhead.
Yeah, that's the problem, because it is people doing this supposedly terribly straightforward job that have now got to sort of try and grapple with the Building Safety Act. And if Mr. Gove sort of promises of trying to do something with Leasehold, come to fruition, well, it's us at the coalface again, who are supposed to deal with this. But I wonder, Stu, actually, given that there is, at least this question mark within the market, as frankly posed by government, around leasehold more generally, because I mean, cladded buildings that they've been a bit of a red flag for conveyancers for some time anyway. I think the Building Safety Act and the combined efforts of Nationwide and Barclays have just made that worse.
Yeah.
But on the much broader point, the millions of properties that aren't cladded, the millions of leasehold properties that aren't cladded, if a member of our government says, this is an outdated feudal system and I want to do something about it, what advice in general terms should conveyancers be giving to their clients purchasing leasehold properties today?
Well, we're here to advise, not to make clients' decisions. And at the end of the day, you've got a title, you've got a lease secured against it. Your job is simply to advise the clients on the contents of that lease, and of course, your client's lender. I'm not sure how much more you can go into this. I just think it's so ill-advised at this moment in time to make those statements, and that's going out to insurance companies now that don't have the appetite to insure conveyancing, and clients in general in this kind of market. It's just not good. But I mean, what can you do now as a conveyancer when you've got statements like that flying around?
Well, that's my concern, really, Stu. So, for example,
how on earth you can't all of a sudden say, "Well, okay, we're not going to act on leaseholds full stop," can you?
Well, some firms will. I bet.
What, leaseholds full stop?
Yes, I like to bet you that, because one of the questions I posed to myself.
I'm not sure commercially whether that's viable. I mean, there's leaseholds in certain circumstances, but as a generalisation, all leaseholds.
I like to bet you there are some firms that will take that view. I like to bet there are.
I'd be interested if people make some, leave some comments to see whether that's a serious proposition, because that's an awful lot of transactions that you would not be dealing with, an awful lot.
Would conveyancers be in their reports, Stu, right now, in the light of Mr. Gove's comments? Would anybody be adding something in their reports to say something along the lines of, there have been question marks in the press about, the government's attitude to leasehold moving forward, and, we can't comment on whether, what you've got now might be what you end up with in 3 years' time, 5 years' time, sort of thing.
I think there's a line, and I'm not sure personally whether that will be going too far. I mean, you could say anything on that basis. If you're going to go down that line, you could say the same about a freehold. You know, what might happen in the future?
Well, no,
who's going to say in 20 years' time that all of a sudden the government might come out and say we're going to bring in another type of tenure or whatever?
Said something about leasehold. That's the point, isn't it?
Yeah.
They have made a statement from the very top of government.
But there's no substance to the statement, is there?
There very often is.
No, there isn't, but it's very loose. There's no substance to behind what he's saying. And I'm sure he doesn't actually mean or particularly think that if you own a leasehold property, or if you've bought a leasehold property, you don't own it. You know, we're forgetting the absolutely Christ knows, you know, how many leaseholds that operate, you know, with no problems whatsoever. Millions of them.
Of course, that's the problem. It, of course, is always the vast majority. But
yeah.
But I wonder, Stu. But I you see, what I just wonder though is whether, you know, particularly our regulators, the indemnity insurers, everybody has sort of 2020 hindsight. So if, for argument's sake, let's just continue the argument, you know, something hits the fan in 2, 3, 4 years' time, and leasehold does become something of a toxic estate in land, you know, this is the point that would be identified as the point where a question mark, January 2023, this was the first question mark that came from the top of government about leasehold. So wouldn't indemnity insurers, as I say, our regulators, anybody that, you know, the ombudsman, anybody that's say, well, conveyancers, you were aware at that point in time that there was a question mark over this. Why didn't you at least point that out to your client so they had, you know, full? I
don't think there's enough substance behind that article to warrant you maybe, you know, changing your reports. I'm not sure if you're going to go down that road where you draw the line. And again, you could totally do this the other way, couldn't you? You could maybe put somebody off buying a leasehold property, and all of a sudden they could come back to you and say, well, you put me off buying it. You know, all of a sudden prices are now going up again. You know, I've just lost out on something that, you know, I'm now going to pay another 20 grand for. So therefore, you know, are we negligent because we put somebody off buying it when they could have done it at a lower price? Blah, 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 blah.
Yeah, that's a really good point.
I'm not sure there's enough substance behind that article to warrant that effect. I mean, you could go on and on here, couldn't you? You could pick any specialized subject and say, well, if you're going to buy anything now that's, you know, got this problem, it might be different in X amount of years' time. I'm not sure. You know, there's got to be some kind of reasonableness to what we do. And at the end of the day, you can only act on what's in front of you, surely.
Yeah, no, I'm not agreeing or disagreeing, Stu. I'm just lobbing the idea out there. I mean, I suspect that some firms...
It's getting worse and worse, isn't it?
It is.
You know.
I mean, I do think that if anybody's going to bone up on anything in the next sort of couple of years, then...
Up?
Yeah.
What's that mean? I've never heard that word before.
Revise. Check out.
Okay.
Right, read.
Okay.
If anybody's going to check something out, then they probably could do worse than reacquaint themselves with common hold. Because, I mean, as you said earlier, Stu, the kind of structure, the statute, the provisions, it's already there. So if anybody wanted to replace leasehold with something, how you would do it retrospectively, completely different question, but that's a different question. I mean, it would be fairly easy to mandate that, you know, new developments from date X will only be issued on common hold. That would, over time, you know, phase the problem out to some extent.
That's not what he said, though, is it? He said abolish leasehold, I think might have been the term. That's the difference. Maybe if the article was to be pro common hold, and maybe sort of, you know, introducing more common hold over the years was the plan, that'd be a totally different conversation to be had, wouldn't it?
That's what I mean about, you know, the throwaway comment, I think, being quite, you know, ill thought out. Because, again, this idea that, you know, it should be easier for leaseholders to, you know, buy out the freehold. Well, he's clearly not sat and listened to, you know, enfranchisement specialists, for example, of which I'm most definitely not, where you have the sort of myriad of different people and entities owning you know, leasehold, being registered proprietors or whatever of leasehold estates, trying to get them to sort of act in any cohesive way, and trying to get the appropriate percentages to enable such rights to be exercised is an absolute nightmare. You know, I do just, and it would, to be fair, I mean, you know, to try to be balanced about it, I mean, it would be quite interesting actually to get the view of a developer or two, Stu, on this, because they may well say, well, you know, well, okay, we'll take our teddies and we'll go and build something somewhere else, but we won't build flats there because you're just making it far too difficult for us. That's
well, especially if they can't sell them.
Yeah.
But wouldn't it would be interesting, wouldn't it, if you did speak to a developer and we actually asked them about common hold? You know, what would be the chance of somebody actually building a common hold development? Because there must be question marks, maybe against lending on common hold. I've never actually ever transacted on a common hold.
No, I think at the time it was because I mean the death knell for it, to my mind, was when reference to it was quietly removed from the standard conditions of sale in 2011. You always knew then that's the point at which common hold died. But I think the land registry only had, I think off the top of my head, about 3 common hold developments. And of course, it's the chicken and egg thing, isn't it? Because if it's not used, I stand
to be corrected, but I think there might be nearer 20. I might be wrong, so definitely don't quote me on this, but I've got a figure of 19 in my head.
That's a very specific figure.
I know, and I'm completely, this is off the cuff. So, but I'm sure once, I actually had to give a quote for a common hold about a year and a half ago, and I think I Googled how many there were. I thought 19 came up, but I might be totally wrong. I might make myself look a complete fool now. Especially, I know it happens all the time, especially if it came back and it was 3, then I really would look like a prat. Yeah, exactly. But I'm sure it was something like that anyway. I'm sure it was double figures.
So did you accept the quote, or did you give the quote, or did you just decline to give it?
I was in such a dilemma because I wanted the quote to be obviously accepted, but I was a balance of, well, it could be a bit more complicated, so should the quote go up? But on the other hand, I really want to do a common hold. Should the quote go down or be balanced? But either way, I didn't get it anyway. And I suppose, you know, the weird thing is nobody actually asked me, had you ever done a common hold before? Because that would have been the most sensible question maybe to ask when that quote was being given. But anyway, the question was never asked, so the answer never had to be given. But I would be interested to hear from somebody that might have done common hold. And maybe that would be another chat for another day. If anybody out there, lawyer-wise, has transacted on any common holds, it would be interesting, wouldn't it? Because I'm not sure where the land would lie, and I suppose I haven't really started to think about it too much until now. But you know, where does the land lie with the lender?
Well, I think most
would common holds be saleable? You know, if you were to advertise a common hold, would it be as attractive to buyers?
Off the top of my head, I think the Part 2 say they will lend on common hold. The part, you know, the Part 1 of the handbook. But
I think they would. But in terms of reporting, I suppose, I mean, I've never seen one, so it'd be very interesting, wouldn't it?
Yeah, I mean, I think there's a ready-made answer, but I mean, well, I suppose to bring this chat to a close, I mean, so you know, let's put our money where our very large mouths are. So we posed the question at the beginning: will ending leasehold really happen? What do you think, Stu?
Don't think so. Be quite certain on that one.
Yeah, my fear is, and I tend to agree with you, Stu, because I do think actually the fundamentals of what leasehold is about, actually from a legal point of view, deals with the legal problem that it was always intended to deal with.
It's too generalised, isn't it? To say all leasehold is bad, which in essence is what's being said here, is too much of a generalisation. Yes, there are aspects of leasehold tenure that could be better, and there are problems with leasehold tenure. We're all aware of that, as especially in this climate at the moment. But to generalise to the extent that all leasehold are bad and that they should be abolished, surely is fanciful.
Yeah, I would say so, Stu. I would say so. My fear is that actually this sort of comment will have more of a chilling effect on the leasehold market more generally.
Definitely.
Without any question.
Yeah, it's bad timing.
And also, I also fear that there'll just be some technical tinkering around the edges, which again will just add uncertainty, and if the lenders weighed in with that sort of thing as they have with building safety, then conveyancers won't be acting, but not necessarily because there's a problem with leasehold, but because of the outside pressures from elsewhere. So if the lenders ask us to, quote, verify, unquote, everything, then I think conveyancers, that's what will prompt conveyancers to walk away. It won't inherently be the problem or other with leaseholds, I think. But you know, if any government representative wants to come on and have a chat with us about it, as ever, we'd be delighted to welcome you. as our parting pitch. Well, thanks for that, Stu. And well, I hope to see you soon. Take care, mate.
Take care. See you soon.
Bye.